Hi, everybody. This is Jeff Fowler with the Apartment Owners Association, and it's great to have you with us today. I know many of you are new members, potentially watching from AOAUSA.com. We just sent out an email that has a link to the Zoom, so you can come and join the Zoom meeting. We take questions from there first, and it's just way more engaging to see people and to interact instead of just answer questions in the chat. But we want to welcome you. And anyway, we're going to talk about how to properly complete an AOA lease agreement. We have the newly revised rental agreement here, so we're going to cover that. And specifically in the context of LA rent control, or LA RSO, rent stabilization ordinance as they call it. And so even if you're not LA RSO, 95% of what we cover today will be helpful for you. We covered this on Saturday in person here at the AOA headquarters and had a great time with everyone, and we're able to answer lots of questions. This is it's so key, it's really mission critical to fill this out. And fortunately, we have an attorney who's going to walk us through it today. And anyway, so let's see. One thing, the LA city and other places, like, things change all the time. It's constantly evolving. So make sure that you verify what's required for your specific jurisdiction, including LA. Because when you watch, some people are watching this live today, other people, when you watch this as a recording later on, we can't guarantee that there won't be something that changes in LA city. And anyway, we do have in March, I know you guys are not going up to Northern California, but we have Bay Area Landlord Power Conference. April 15th is the AOA $1 Million Trade Show. And we want to invite all of you. We're going to have definitely 150 vendors that'll be there. And so they're there specifically because they believe that they have products and services that are going to help you with your property management. And we'll have lots of different speakers. And anyway, so go ahead and sign up for that one. It just streamlines registration when you sign up. And our speaker today is going to be speaking on March 12th, and he's going to cover defenses that derail housing providers. He's going to cover that on March 12th. And so, yeah, just so thankful for SNS Law Group. Lots of 5-star reviews. They focus on real estate and business law. And our special guest today is co-founder and partner at SNS Law Group. Before earning his JD and co-creating SNS Law Group, he found passion for real estate management and development. He's managed over 100 million in assets for his clients. And anyway, so we have Bijan Shakibkoo with us. And so, man, it's great to have you with us today. And if you guys hold your questions till the end, he may answer some of them. But as they come up, definitely maybe note the paragraph that it's referring to when you ask the question, because he'll be kind of covering things, section by section there. So anyway, Bijan, great to have you.
Thank you, Jeff. It's always a pleasure to be here and always informing your viewers. And again, like I say in every single webinar, you guys do God's work over here and helping landlords to be able to understand what they can and cannot do with their properties, and how to efficiently be able to properly manage their properties as well. So today is a little bit different mainly on all of my webinars that I've done with you guys. We're going to do a little bit more hands-on, informative with the rental agreements that AOA provides. And I am in love with AOA's rental agreements. I think it's a very, straightforward rental agreement. It covers all the main bases. Obviously, every property has specific, things to it, depending on whether if it's a rent control property, if it's a single family home, or if it's a multifamily. But for the purpose of this webinar, we're going to get into learning about how to fill out the lease agreements. I do have a lot of clients who, whenever I am processing eviction actions, I do see lease agreements that are filled out incorrectly, and it's interesting. A lot of my clients have AOA leases, and apparently, as straightforward as it really is, mistakes can happen. And that's just because, they're not familiar with how to fill it out. And that's why we're going to really learn on the best way to do it and how to make sure everything is done correctly. Because in the event if something does happen where there needs to be an eviction or a lawsuit, your attorney will be able to easily breeze through it and cite specific clauses and whatnot to be able to get to what the client needs. So we'll start off at the top here. It's pretty straightforward where it states over here, owner, agent, lessor. You're going to put your name over here. I put SNS Law Group because, I'll be doing a webinar today. So John Doe, for the name for the residents and the tenants, this is the most important part. It's very important to understand whose names you're putting over here.
Mhm.
As a rule of thumb, and I always tell my clients this, it's important to make sure that whoever is the adults that are residing in the residence, who have filled out the credit application, who have went through the proper steps to be able to see, for the landlord to be able to see who the tenant is, they have to be included in here. Now, we're going to go down further into occupants, but again, whoever is residing in the unit that is not a minor or who is not a caregiver, I recommend their names being listed as the tenant. And the reason being is because they are going to be contractually binded to the lease. If you have an occupant who could be an adult that is residing in there, that is not named on the lease agreement, it makes it difficult for me as an attorney to bind them, especially when it comes to eviction actions. So that's why it is imperative to make sure that whoever you have coming in to be able to rent the unit or the home, make sure that you include all the adults in there. Minors, unfortunately, cannot be included as a named tenant because they cannot contractually bind themselves due to the fact that they're minors. So as for the minors, I would recommend putting them under the occupant section. And I'm just going to go in and discuss the fillables. If we have any questions in regards to the clauses, I'll be more than happy to address them. So that's for the name tenants. Make sure you have their correct names as well. I always like to get an ID from them. So any identification, any government identifications, whether if it's a California license or if it's some sort of a passport, something that has their legal name, which is very important to include on there because, again, when you are filing lawsuits, you want to make sure that they have the right name so they don't bring it as defenses. Or even if you get a judgment and you want to be able to collect from them, if the name is not correct, unfortunately, you're not going to be able to collect. So that's for the tenants and the residents. We get into the address. Now, it's very important to make sure that the address is correct for the property. Make sure you include the correct address because if the unit number isn't there, and again, a lot of viewers, they have duplexes and multifamilies. So it's imperative to include the unit number on there. I've seen lease agreements where they would just put the address without the unit number. And that makes it difficult for me to be able, and we process many evictions in my office. It makes it very difficult for me to be able to process the eviction action because there is a dispute in regards to what the lease agreement says and what the actual residence where the tenant is living. So make sure you don't miss this. In addition to that, that goes for the city, the state, and the zip code. This is pretty straightforward. Now, the monthly rent, that is obviously up to the landlord as far as what they want to charge for monthly rent. Just make sure that is filled out. The rental due date. Now, I've seen a lot of times when I do review lease agreements from clients, they have the rental due date missing, or they never included the rental due date. It is imperative to make sure you have the rental due date on there because that way, what it helps me to do, for example, if there is eviction for non-payment of rent, if there is no rental due date, then it's what it really reverts to is operation by law, which means that whenever the tenant usually pays the rent, that's what the rent due date is going to be. So it makes it very difficult for me to be able to understand when I could be able to issue a 3-day notice to pay rent or quit if the rental due date is not there. So make sure that you have the rental due date there. It's important because that way you could be able to gauge as to whether or not the tenant is in breach for the non-payment of rent. Going into the security deposit, security deposits are you have to include the amount here. Obviously, what I wrote here is the cap at 1 month. There are specific properties that are exempt from that, and those properties really come down to whether if you are a natural person or a LLC that do not own more than 2 residents with a total of 4 combined, and that is a state law. So in the event that you are exempt from this law, then you could exceed the 1 month security deposit threshold. If you don't fall within that and you're not exempt from that, then the maximum that you could be able to recover is 1 month. So for example, let's say that the monthly rent over here is 1,500. Okay. If you're not an exempt property, then it has to reflect the same amount of what the 1 month rent is, which is going to be 1,500 here as well. Okay. If you are exempt, then obviously you could be able to increase that to, whatever amount you'd like. But again, just depending on the type of property you have, make sure you understand whether if you do fall under those exemptions or not. Going into the late charges, late charges are very interesting. You could put a max at 6%. Again, the whole premise around that is it has to be a reasonable amount, because if the late charge is an egregious amount, then there is case law that states that it's more derived as a penalty. And that is against the civil code. So 6% is a fine percentage. There's no issue with that. But another issue with late charges, and I've seen this happen a lot of times, where I have clients that would go ahead and issue 3-day notices to pay rent or quit. And within that, they would also include the late charges. Unfortunately, you cannot do that. So if you're ever issuing any notices to a client for non-payment of rent, it could only be the base rent. You cannot include any other type of charges. So just keep in mind that if you are, collecting late charges from a tenant, that's fine. I have a lot of clients that tell me that, they pay late every single month. And if you do have a property in the city of Los Angeles, obviously there's a threshold that needs to be met until you could be able to issue that tenant a 3-day notice. What I tell my clients all the time, if they do want to keep track of the late charges, what you could do is just put the tenant on notice every month that you paid the rent late, therefore you have incurred a late charge.
Hey,
If
Bijan, on that, we're gonna make this one specific to an LARS that's subject to the LARSO. So for them specifically, is it 6%? Can they charge 6%, or is it a different number?
For LA RSO, there is no specific amount that I'm aware of that you could charge on a late fee. I think it's just whatever the contract states. Again, if we're talking about for the premises of an eviction action, obviously, when we go to late charges, we cannot use that as basis for an eviction. So, I have no issue with the 6% if it is a rent control property. I'm not aware of any limit to that as for RSO buildings. But in any event, the point that I really want to get across is if you do ever want to create a 3-day notice for non-payment of rent, make sure that late charge is not included in there.
Great.
So getting into the parking spaces, this is actually I feel like this is a very important space to fillable to be able to make sure you put in there. And the reason being is because obviously a lot of properties, they do provide parking to a tenant. What I like to do and what I like to tell my clients to do is not only do you have to put, if there are parking space numbers, that's fine, put the parking space number. But some properties are situated differently. And if the property is situated in a way where it's not clearly defined as far as which parking space has a number, I always recommend creating a additional addendum, and AOA has a general addendum that you could add to the lease where you could specifically specify that parking space. And the reason being is because there is a lot of times where I've seen issues where clients would come to me and they would tell me, oh, the resident is not parking in the correct space. And I will go back and take a look at the lease agreement and I would see that they don't even have it filled in. Or they will have a parking space there, but it doesn't reflect what the actual property, the way that the actual property is situated. For example, the property doesn't have a space named parking space number 2 on it, or where the stall is. So what I like to do a lot of the time, take a photo of the parking space and then include it as an addendum to the lease agreement. That way it's clear to the parties of which parking space they have. And I will tell you why this is a benefit, because especially if you have an RSO building in the city of Los Angeles and you want to figure out ways to be able to evict your tenant, and if they are breaching the lease agreement by not parking in the correct space, that's a ground that you could use to evict them on, and which I've been successful at. So that's why, majority of lease agreements, especially for RSO buildings, they're imperative to have, because it will allow you to be able to use the clauses in the lease to be able to enforce any breaches, or for just cause properties like the ones in LA, to proceed on an eviction action. So that's why I think it's very important, if you do have a parking space, take a photo of it, include it as an addendum to the lease agreement, specify where the space is, so that way there is no discrepancies or disputes as to which space they have. Storage spaces. This is another issue that I've seen happen many times, where there would be tenants in the property in which where the parking spaces, they would start storing stuff next to their cars. And this is why this portion is so important for the storage space, because when we're referencing storage spaces here, this is actually separate from the unit. So we're not, a storage space is not within the unit, it's actually separate from the unit. And if you don't specify whether if they have one or not, a lot of times I've seen where, tenants, unfortunately, some of them would be hoarders, and they would just start compiling stuff around the property. And if you don't have the lease agreement to be able to specify whether if they have storage or not, it kind of ties my hands as an attorney to enforce that. So I always recommend, it depends on the owner. I always recommend putting none on this. That way it makes it clear to all the residents and the tenant who signed the lease agreement that they don't have storage. So that means you can't just lay your stuff around the property and make it and turn it into a nuisance. If you do decide to give storage to the tenant, again, I would specify that exactly where the storage is. That way, if they start leaving stuff around the property, they'll be in breach of the lease agreement. Going into the commencement. So it's interesting because I've seen clients make mistakes on this all the time. It's very important to be able to state when the lease is commencing. That doesn't mean when the lease was signed. This is the date that the tenant actually has possession of property. So if the commencement, for example, is on February 6th, that's the date that means that you've given them possession to the property. In addition to that, I've seen a lot of clients, they will fill this part in, but they won't check off whether if it's a month to month or depending on how long the term of the lease is. And this is really important because if you want to be able to determine when the lease expires or when it reverts to month to month, if you don't have this specified here, it becomes ambiguous, which is why you need to be able to specify, because under operation of law, if you don't specify it, then it's technically a month-to-month agreement. Because every single month that the tenant pays rent, it renews the tenancy every month. So I always suggest to make sure that you fill this out. For individuals who do not have a rent control property and that are not in the city of Los Angeles, this is even more imperative. For example, if you have a single family home and there is no local ordinance where there's any just cause, and if you didn't specify when the lease terminates, at that point, it's going to make it very difficult for me as an attorney to determine whether if I can issue that tenant, for example, a 30-day notice to quit for no fault or a 60-day notice to quit. So that's why it's very important to make sure that you have this issue, this A and B, whether if it's A or B, checked off. If it's month to month, it's pretty straightforward. You just click that off. If it's a year term, what I always like to do, like for example, to make it easier for the viewers, if you have a lease that commences on the 1st, then if it's a 1-year term, then you would do it to slash, I believe there is 30 days and 31 days. Yeah. So it'll be 31 slash 26, 2020. If it's a 1-year term, it'll be 2027. And that way it establishes that there was a 1-year term here. Going into the other fillables. And again, going back to the commencement date, it really determines on how long of a term that you want to do, but make sure you include that in here. Going into payments, this is a very interesting portion where I've seen a lot of mistakes happen as well. And to clarify this, the only amount that you're putting here is the initial rent payment. So for that month. So for example, if the monthly rent payment is $1,500, which is the base rent, not including the security deposit, then you would put $1,500 here. For the period of, so it depends when the lease commences. So if it's the 1st of the month, then you would put the period of the 1st of the month. If it's a prorated, like for example, if they're coming in the middle of the month and you're prorating them, then you would put that specific amount of when that period of the proration. So just keep in mind, whenever you are filling this out, it always comes back to when the lease agreement was commenced. So if they're coming in the middle of the month, if you're going to prorate them for that month, go ahead and put the prorated term. If they're coming in the beginning of the month, then you could leave it as the 1st of the month. The security deposit, like we put over here, 1,500 to the 1 month here, which would be a total payment of $3,000. Getting into the payable, this is also important because it has to clearly define who you're paying the rent to, who they're paying the rent to, and the address where they could deliver it to, the city, the zip code, the telephone number, and then the days of when, if they do want to drop it off, what days they could drop it off, and the hours that could drop it off. Now, the reason why AOA, and from my understanding, is that they specified this term this way is because State law requires that there has to be at least one form of non-electronic payment. So for example, you cannot limit the tenant to just pay electronically only. They also have to have an option to be able to pay non-electronically, whether if it's by a check or a cashier's check, some form that is non-electronic. And what this clause does here is actually, it takes that out of the way where you're going to run into that issue that they were never provided a means of non-electronic payment. So if you do want to do electronic payment, again, it's fine. For the purposes, I will tell you this, for the purposes of an eviction action, for example, which I've seen happen many times, is where a tenant will go ahead after the notice has expired, they would Zelle their payment again. And for those of you who receive Zelle payments from tenants, you would know that it's very hard you cannot block them from paying you. So the payment comes in, and then you're going to have to go out of your way to be able to reject it and refund them the money. So it's a lot easier if they do make payments, that's not electronic for eviction purposes, because then they cannot just automatically start depositing or selling the money to the account. If you do have, there are some property managers or individuals who own multiple properties where they use some sort of management software with a portal that they pay through. Those options actually do give you the option to be able to close their portal so they can no longer make payments in the event that there is a non-payment of rent, 3-day notice pending. So for payments, you could just, you fill out whoever is payable to. So for example, over here, it will be, SNS Law Group. And then the address to deliver it to, which, you just put the address of wherever you would like them to deliver it to, the city, the zip code, the telephone number of the individual, and make sure whoever's telephone number that you do put there is an actual valid number in which if they call, someone's going to answer. And then in addition to that, the days that they're available to be able to, so whether if it's Monday, it could be Monday through Friday, for example. But again, depending on your circumstances, just make sure you specify those specific days. And then also the hours, whether if it's from, 9 a.m. to, 5 p.m. So it's very important to make sure all of these are filled out here. Because that way the tenant cannot make a claim as to, I didn't know how I was supposed to pay the rent, who I was supposed to pay it to, where I'm supposed to pay it to. This clarifies all of that. I've seen a lot of times, and going a little bit off topic here, where the tenants will go ahead and claim that they paid the rent and that they came there and they dropped it off at a mailbox. I'm not in favor of dropping off checks at mailboxes, because what I've seen happen in the past before is where a tenant would take their phone out, they would record themselves dropping it off, and then they would end the recording and they would actually take the check back and put it in their pocket. And they would use that. And I've seen it being used as defenses in non-payment of rent cases where, they would bring this video into evidence showing that they're actually making the rent payments. But in the case that I had, I was lucky enough that, my client was lucky enough that he actually had cameras on the property showing the tenant doing that, of putting the check payments in there and then taking it out. So, again, it's always, if they're mailing it, I think that's the best way to do it than having them drop it off, because then they could always, create some issues saying, I dropped it off, it's not my fault. But when it's mailed, they have to show proof of that. Getting into the late charges. So when we're filling this out, this is where it becomes a little bit it really depends on the owner themselves. I always recommend doing by putting that if they fail to pay by the end of the third day. Um, Realistically, you're not required to give them a time period. This is more purposes for the late fee that's going to be generated. I've seen a lot of individuals put it on the third day. For purposes of, non-payment of rent cases, because this is what comes to my mind as an eviction attorney. Um, this doesn't matter. This only matters in the event that you want to incur late charges from the tenant. Um, if you have the specific due date here of when the rent has to be due, then at that point, if they don't pay by that day, they're delinquent. But for late charges, that's why you could put a specific period of time as to when they don't pay by when they will incur that late charge. Um, the percentage here, again, it's up to the owner as the amount they want to put. It is maxed at 6% according to the AOA lease. So you could do it anywhere between 1 to 6%. It's just however the owner would like it to be charged. Have I seen landlords been successful in breach of contract cases for late payments? Yes, but again, with full transparency, um, the amount that you're going to spend on an attorney to go and collect that amount, does it really weigh and balance out? That's something that the owner needs to take into consideration. But again, it's very important to address it every single month that they are being late, because that way you're putting them on notice of it. And it puts more pressure on the tenant to understand that, the owner is not just going to roll over here. If you don't pay on a specific date, then that means you're going to incur that late fee. Another portion of the late fee is that if the owner elects to accept rent after, let's just say if you put the third day here, after it was due, then the payment in the form other than the personal check may be required. This just means that, it has to be either through a different type of form of payment other than personal check. Getting into the security deposits, this is pretty straightforward. It says here that upon signing this agreement, residents shall pay to owner the sum of, and that's exactly what's stated over here, the $1,500 security deposit. And the reason why this clause is here is just to make it clear that that is the security deposit amount. And in addition to that, there's other language as to how the security deposit gets applied and whatnot. When we get to this portion here, I put AB 414. That really that is the assembly bill that requires landlords now to be able to, that if the tenant does decide to make a payment electronically through the security deposit, then it is required for the landlord to specify the bank account or the financial institution as to the destination of the return of any unused portion of the security deposit. So that just makes it at ease, as in the event once the tenant vacates, you're returning it to that same financial institution with whatever the bank account, whatever that institution was. And then if you want to, dive a little bit deeper in understanding it, you guys could always look up AB 414, and that really clarifies as to the duties that the landlord has for the electronic security deposit payments. Another thing that I want to touch in on, which is kind of separate from this, for security deposit payments, if you have a rent controlled property in the city of Los Angeles, just keep in mind that the tenant is entitled to interests on the security deposits that they pay. If you look up under LAHD, on Google, just put in LAHD security deposit interest amounts. There's a breakdown on the percentage that the tenant is entitled to. And the landlord has a right to either be able to provide that in some sort of a rent credit to the tenant, or at the end of the lease term, apply that towards the end of the lease term. But again, the whole premise around that, and why I state it, is because it's very important to be able to make sure that you're keeping track of the interest on the security deposit for rent control properties in the city of Los Angeles. Getting into utilities. Every property is situated. It just depends on whether if the landlord is what kind of utilities the landlord is providing to the tenant. Majority of my clients, the landlord does provide water, but gas and electric are separately metered, in which the tenant would be responsible for. If the tenant is, for example, in this circumstance, it says residents shall pay for all utilities and or services based upon occupancy of the premises, except, and for the example that I made earlier, water. If the water is not separately metered, which a lot of multifamily buildings in the city of Los Angeles that are RSO, because of the year that it was built, the water is not usually separately metered. If it is separately metered, then you don't need to include it, because then the tenant will be held entitled to pay for it. Getting into the check mark here, this specifies whether if the premises do or do not have a separate gas or electric meter for each residence dwelling unit. So if they do have a separate gas or electric meter, then you would check off that it does. If it does not have a separate gas or electric meter, then you check off that it does not. And that's pretty straightforward. Getting into the occupants, like I mentioned earlier, I always recommend for landlords to include all of the adults as the tenants, and whoever is filling out the credit report and the application. This portion really applies to minors or caregivers, and that's where I would include them in here. And obviously, you can't a binder cannot contractually bind themselves to an agreement. But it's important to clarify that in the lease agreement as to who these occupants are. What I've seen happen a lot of the times are where, especially for older properties, where they had occupants that were minors, named as the occupant, but they have become, they're no longer minors and now they're 18 years older. At that point, again, if the lease agreement already has them as an occupant, for an eviction standpoint, we do try to include everyone, because now minors are not really protected. But for this portion, and for the purposes of creating the lease, I would include the minors or any caregivers as an occupant. If they're adults, you always want to make sure that you could contractually bind them. It's also very important to be able to make sure that all the signatures and the initials are placed here for the tenant or the resident. Getting into animal and furnishing. So with this clause, what it says, and I'll read through it with you guys. It says, said consent, if granted, shall. So I'll go to the beginning. It says, in the event that you do have animals or furnishing, if the landlord consents to it, it shall be revocable at owner's option upon giving a 30-day written notice. In the event laws are passed or permission is granted to have any item prohibited by this agreement, or if for any reason such item exists on the premises, there shall be a minimum additional rent of 5% a month for each animal if another amount is not stated in this agreement. Now, I want to make sure that the viewers understand this clause is really important, and it really depends on where your property is situated. If you have a rent control property in the city of Los Angeles, this is where it could kind of get into murky waters here, where whether if you can charge an additional percentage. as for animals who were brought into the property. What I would say is if you do have a rent controlled property in the city of Los Angeles, um, it's always better to be on err on the side of caution. I did put 5% here as for an additional rent. But again, for example, if we're getting into the COVID period, if there were any animals that were brought in during that period, then you were not allowed to charge an additional percentage for the animal if the animal was brought in for hardship through COVID. But for the purposes of this webinar, I put it at 5%. So, but if you do have a rent control property, I would say just call my office so we could just dive a little bit more deeper into it to make sure that, whatever percentage that you put is legal under the municipal code. But again, there's also a separate addendum that AOA provides for animals. I always like these separate addendums because not only does it put the tenant on notice of what damages they'll be entitled to if the pet does create any damages in the unit, but in addition to that, it specifies what kind of animal it is, and in the event if they bring in more animals or different animals, then they're breaching the lease. So it's always important to have that animal agreement addendum if you do decide to allow them to bring animals. I've seen a lot of the times where, the lease, they state that they don't have an animal, and then in the middle of the lease term, they would bring one in. Well, if you stated in the lease agreement that, there was no animal and they brought the animal in without the owner's consent, then at that point they're breaching. I would want to, on a side note, on an eviction standpoint, I've seen a lot of tenants raise that the animal was brought in for, a reasonable accommodation or because they have some sort of a disability. That's when you start to get into a lot of murky waters because they have specific protections and you have to go through a process with the tenant to make sure that you're not discriminating against them. So for purposes of having a tenant, I always, if they don't have an animal at that time, just make sure you clarify that in the lease agreement that there is no animal or pet. That way, if they do bring one in, you could be able to enforce it. Because I've seen a lot of times where tenants would bring in animals and then they would completely destroy the unit, especially if the owner is not cleanly. Getting into clause 13 of the lease agreement. This really this falls into the new law that was implemented, which and the civil code is not triggering in my head right now. I believe it is it states it here in the agreement, but I always like to have it off the top of my head. But what it applies to are properties now. If you're ever renting a property and there are specific properties that are exempt from this requirement is where you have to provide a stove and a refrigerator upon signing of the lease agreement. And if we could walk through this together, if the property is subject to the state requirement, then you would check this off. Okay. And then it also specifies as to this, if it is subject to it, a stove is non-negotiable. You have to be able to provide them a stove. But in the event that you, when it comes to the refrigerator, if a refrigerator is provided by the owner, in which if you do provide that refrigerator, then it specifically states, clauses in there that they have to keep in a clean and sanitary condition. If you do not provide them, if they provide their own refrigerator, so if they bring in their own refrigerator, then there's also specific clauses in there that the resident shall provide and maintain their own refrigerator at the resident's sole expense. And that is required by state law that you have to be able to provide them either a stove and refrigerator. But there are specific properties that are exempt from that. And if you take a look at over here, if that property is exempt from that, and if you state here what the exemption is, whether if it's a permanent or supportive housing, or if it's a single room occupancy, or if it's a unit in a residential hotel, or a dwelling unit with a housing facility that offers a communal kitchen. So I've seen a lot of times where it'll be a single family home, but they'll rent out, a bunch of rooms in there and there'll be a communal kitchen. At that point, you could check off that it is exempt. So this is why it's very important to understand what kind of a property that you have. That way you could understand whether if it's exempt or not, and whether if you do have to provide them a stove and a refrigerator. Also, make sure that all of the initials here are filled out whenever you're having the lease agreement by the residents, not the occupants, it's the residents. Getting, again, over here, make sure that it's all filled out, the initials. So there are some lease agreements that there are additions and exceptions to whatever clause is here. That obviously depends on, the owner and the type of agreement that they have with the tenant, which is why you could, include that. Some additions and exceptions that I've seen here in the past are when it comes to water. And there are separate addendums to that, but what I've seen here, they'll specify, a portion of what the tenant is going to have to pay towards the water if it's not separately metered. Again, this is between, the owner and the resident as to what exceptions or additions they want to include in here, but it's always important to have that if you want to, clarify the understandings of the parties. Again, make sure you have all the initials here filled out. Coming into clause number 37, and this is for notices and requests for repairs. This is always, I really, I think this is a very important clause here, and it's because it allows the tenant to understand who they have to be able to reach out to in the event they need some sort of repair done, or who is going to be the point of contact under this lease agreement. So if there is a manager for the property, you could put their name, their address, their telephone number, and their email that the tenant can reach out to. If the owner of the property or person who's authorized to act for and on behalf of the owner for the purpose of service of process and for the purpose of receiving all notices and demands, what this means is, in the event if there is any legal action taken, if there's any demands that need to be made by a tenant, this is the individual that you put that the tenant has to reach out to. So their name, their address, their phone number. Now, what I've seen happen a lot of times is where, this portion is filled out, this portion is not, and then the tenant won't know if they do, if that day does come, God forbid, that there's an attorney that gets hired and they want to send it, notice of demands. They don't have this. Obviously, they're just going to send it to the manager, and you won't be, depending on the relationship between you and the individual who's managing your property. If you're not actually put on notice, then it creates a lot of ambiguity and miscommunication between the parties. So just make sure that you have the proper personnel here. I always recommend the name here to be the actual owner of the property, because that way, usually the owner is the one who really wants to know if something is coming down the pipeline as far as notices and demands. As far as the person or entity authorized to receive payments of rent, this is also important to include. It also reflects up here, which we spoke about, as far as all payments to make specific persons. Sometimes owners would have a different individual that who is authorized to accept it. So if you have the name of the person who's authorized to accept rent payments, their address, their phone number, also include that in there. But it also, on the second page of lease agreement, clause 2, you could also include the same name. It doesn't matter. But if you have somebody else, you might want to also include them in there too. As far as inventory, This is very important to include inventory because if you are ever providing a unit to a tenant that is furnished, you want to specifically be able to write out everything that was give provided to them. Because in the event, the tenant decides to move out, which I've seen a lot of times, they'll take the furniture. And if the lease doesn't specify what inventory they have or whatever was in the unit or whatever was provided to them, then it becomes ambiguous, right? So that's why it's very important to specify if there is any inventory and what is contained in the unit. That way, if there, whether if it's a dishwasher, whether if it's a washer machine that's in the unit, whether if there's, a couch, TVs and whatnot, this is where you would include that. There's also, and getting to my point here, there's also a check mark here where if the resident further acknowledges that the subject premises are furnished with the additional furnishing listed on the attached inventory, and that said attachment inventory is hereby made part of this agreement. And what this means is it's kind of reflecting clause 38, saying that this is a furnished unit, and these were the items in there at that time. So if you are providing a furnished unit, make sure you check this portion off. Getting into the addendums and other acknowledgments under the lease. There are specific addendums that are required. As you can see here, if it's a lead paint disclosure, this is required, which is why it has an asterisk on there. If it's a rent reporting addendum, and that applies for properties that are 16 units or more, then that has to be applied in there under the lease as an addendum. Same thing for EPA lead. These are very important because depending on when the property was built, as you can see, if it's pre-1978, and the AOA thought about this. It's only or may email. So I always recommend including. This depends on whether the property falls under it, but I always recommend including all of these. As far as pest control addendum, this specifies the person who is handling the pest control and I don't have the addendums up with me, but this specifies the contacted person. But getting back to these addendums, I always like to put as many addendums as possible. That way it puts the tenant on notice as to whether what they can and cannot do. If there are unit keys, you could include that addendum. The move-in inspection, I highly recommend that list because that way it clarifies what was the condition of the unit at the time the tenant moved in, and it's being signed by the tenant, so they're acknowledging that. If there is a pet, then I 100% recommend an animal agreement. House rules are very important, and it's funny because a lot of individuals think that the house rules don't apply to the lease agreement, and they do, in which I have enforced these house rules and eviction actions. So if they're violating the house rules, then it actually gives you a further basis to issue them a notice. If the property has a pool, then you could include pool rules. Common area keys, if that's provided to the tenant, garage remotes, mailbox keys, parking agreement. And that's a very important parking agreement, the addendum that AOA has, I believe it's separate from the unit itself. So if you are charging the individual for additional parking, then you might want to use this parking agreement. Satellite dish addendum, if there is a satellite dish on the property. Mold addendum, I highly recommend, it doesn't matter what kind of a property it is. What I've seen happen a lot of times right now, tenants are filing actions left and right for mold claims. And a lot of it that I would bring in as a defense for these type of actions is if the lease agreement does have a mold addendum, it actually puts them on notice that they have to keep the unit in a specific condition. They cannot, they cannot create moisture in the unit. So the mold addendum kind of is beneficial because it puts them on notice that if there is mold, they also have to let the landlord know promptly. So I always recommend including a mold addendum on there. If the property is smoke-free, include the smoke-free addendum. I think it's very important to include that. These are one of my, this is very important too, because I've seen tenants where the lease agreement doesn't specify whether if they could smoke or not on there, and they're just smoking and the tenants are getting upset. And obviously, as an attorney for me, if the lease agreement doesn't say that they can't smoke in there, then it's going to be hard for me to enforce that clause. Car charging addendum, what I've seen a lot of the times, especially for newer properties, if the tenant has an electric vehicle and they're requesting a charger, then you could include this addendum on there. Bed bug addendum, I always recommend to have. Plumbing addendum, that just really depends on the property. I would include the lead-based paint booklet. Again, depends on when the property was built, but again, out of abundance of caution, I would always include that. Info on dampness and mold. This is an important one. I would include this regardless of what kind of property it is. It teaches the tenant, it puts them on notice on how to handle the unit and not create as much moisture in there where it will be create mold. Flood disclosure addendum, that really just depends on where the property is situated. If the tenant has an e-bike or a scooter, I would include that addendum. Bed bug, I would include that too, because I've seen a lot of times tenants use these claims for cause of actions for habitability issues. And then going to the general addendum, again, this is stuff that you want to include that is outside of this lease agreement. Like I said earlier with the parking, you may want to use this general addendum to specify that parking space and maybe include an image in there as an addendum as well. But again, these are all to your guys' disposal. And depending on what kind of a property you have, I would 100% recommend including these addendums in there. And this is all for the purposes of making sure that both of the parties are clear on how to proceed with the tenancy. Again, make sure you have the initials here on every single page. Receipt of the agreement. Again, this is you're going to include the tenant's initials here. Or if it's just a single tenant, then you can put their initials there. And then the name, the signature, and the date. If the tenant wants to get text and email notification, the owner and the agent and the resident will agree to communicate by text and email, in which they would include the owner's telephone number to text, and email address, tenant's telephone number and email address. I always recommend any communications between a landlord and a tenant to be done in writing. That way, everybody is clear on each other's intention. Because what I've seen that happen a lot of times, where I have a lot of my clients that majority of the communications are via telephone, and that way it's really hard to establish whether if the landlord did do something that the tenant requested to be repaired. So I always recommend everything to be done in writing. Getting into clause 44, this clause really applies to, and I think everyone has heard of the statewide rent control AB 1482. When we're dealing with RSO properties, if it's an RSO property, then you're going to have to check off this one, that the property is subject. Well, I'm sorry. If it's an RSO property, let me step back here. AB 1482 is a statewide rent control. That means it applies to all properties within the state of California. Now, there are specific properties that are exempt from AB 1482. And then there are properties that because there is a local rent control or there's a local municipality, that way they don't fall under AB 1482 because that local ordinance is more onerous than AB 1482. So what I would say is if you do have a single family home that is not, or a condominium that does not fall under the statewide Rent Control Act, then I would check this off. If you do have a property that is multifamily, that is RSO, that is within the city of Los Angeles, then I would check the portion off of the property is subject to statewide Rent Control Act. Again, this portion here where it discusses that there's just cause, if you're an owner in the city of Los Angeles, then you would know that you would need cause in order to evict a tenant. So these portions really apply depending on what kind of property you have and where the property is situated. Getting into the positive rent reporting. So I have a lot of clients that own multiple properties, any properties that are 6 units or more. If that's the case, then you are entitled to provide them with positive rent reporting. If the property is exempt from that, meaning that it's no more than 16 units, then at that point that doesn't apply to you, and you could check this portion off. So going back to clause 45, make sure you understand what kind of a property you have. If you see here, the owner is not any of the following. That means that an owner of a residential rental building that contains 16 or more dwelling units, nor owns more than one residential rental building, while being a real estate investment trust or defined under Section 8. And this is just legal lingo. But just to let you know, if you own more than 16 dwelling units, then the property is not exempt, and you're going to have to check this portion off, that you have to provide mandatory positive rent reporting. There's also I believe AOA has a separate addendum to that you could attach. Again, make sure all the initials are placed in there. And then over here, you put the resident's full name as it appears on their ID, their signature, the date, and it's pretty straightforward. Again, if anybody has any questions in regards to the lease agreement and, depending on how the property is situated, feel free to give my office a call. I'll be more than happy to walk you guys through it and to teach you how to fill it out.
Woo, you did it.
Yeah, it's a lot.
Thank you so much. That's a lot to go through. And
Hey.
do you have some time to answer questions?
Of course. Yeah.
Okay, great. So what we're going to do, everybody who's on Zoom, I know one of the questions people were asking for your phone number. There's this number. For the people in Zoom, they can't see it potentially. It's
Okay.
424-220-2052. Is that the best one for you? Hopefully.
That's correct. That is the best one.
Okay, good. So we got that right. And
Yeah.
what we're going to do is we're going to open up to questions on Zoom. So if you raise your hand, we will take you just in the order that you guys are there. I'm going to remove the pin so I can kind of see. I want to see the meeting people and who has their hand raised. Let's see. Why isn't Jessica showing up? Okay, I'm going to change my view so I can see everybody. Okay, there we go. So Jessica, I'm going to ask you to unmute yourself and go ahead and ask your question.
Hi. First of all, thank you so much for this. Very informative. The RSO, I have a duplex in the city of Los Angeles under RSO and registered, has changed its rules regarding security deposits. So the rule now is that you have to pay the interest either every month or once annually for the entire year, that the landlord may designate what day of the year the landlord wants to pay that interest. And there doesn't seem to be any clause here in the AOA that's reflecting that. It is a new regulation as of 2026, and I'd love for you to speak about that, because they've also increased substantially the rate of interest on a security deposit. It used to be well under 1%. This year they bumped it to 4.5. Thank you.
Yeah, so the answer to that question, I think the best way to go, if the lease agreement doesn't state that, and understand, the purposes of a lease agreement and the way that AOA has drafted it is they're only applying stuff in there that is required under the law to be included in lease agreements. Now, for example, so the AB 1482 exemption. The law requires you for any new tenancies to have that included in the lease. Same thing goes to the offer of a positive rent reporting. That's also the law requires it to be included in the lease agreements. Now, when we're talking about, interest on a security deposit, if you want to include it in the lease agreement, I mean, it would be difficult to be able to, as far as gauging it, because obviously every year that percentage is changing. So for purposes of having it in the lease agreement, I don't see it. I don't see why you would need to include that. But again, it's up to the owner. I don't see a purpose as to why you would want to include it in there. Just what the AOA lease covers is putting everything that needs to be in there. Security deposit interest, obviously they need to get paid every year, but it's up to the owner on how they want to do that.
Okay, thank you. And one more question, which is that the RSO has its own pet agreement that's incredibly specific regarding deposits and everything else. Can you speak about that?
So if you want to include, so if your question is asking me what I can do under the RSO as far as the pet agreements and what requirements need to be met there, again, you have the discretion to be able to create another addendum within the lease that you could include in there, that tailors it specifically to RSO buildings.
Thank you.
Bijan, on that one specifically, ours is an animal agreement, which is different than a pet agreement. But for the RSO, does the ordinance say that you have to use their pet agreement if there's a pet involved, or is it just something that the city's providing?
No, it's not required to include theirs. It's that
Okay. So you can include the AOA one. You can choose to include the one that's prepared by the city. And you can edit the ones that whatever you use, you can also edit if maybe under the guidance of an attorney, probably. But edits can be made to all these things as well.
Exactly.
And,
And which I have
just include your attorney when you're going to do it. But Shoaib,
Yeah.
thank you so much, man. Go ahead and unmute yourself. And then also after you speak, if you can mute yourself, because we might end up hearing you after the fact. So go ahead, Shoaib.
Yes, I had a question about AB 628, the stove and refrigerators. I have a lot of leases that are pre-existing before this rule came about. What if a fridge breaks down or a stove breaks down that the tenant owns? Are we required to repair it or replace it? Also, what is the lead time for us to replace it or repair it? What restriction there is, and what happens if their food spoils? Are we responsible for paying for that?
Okay, those are all good questions. What I would state is is it the tenant's own refrigerator or is it the refrigerator that you provided?
Shoaib, you went away. If you're there, come back.
Oh.
Let's pretend that.
Well, for the sake, let's just say that if it's out of the abundance of caution, I would repair the refrigerator. And now, if it depends if the tenants provided the refrigerator themselves. or if it's by the owner. If the owner provided, then obviously you would want to get that fixed. And the time period to get it fixed is within a reasonable amount of time. So, given the circumstances, if you're, reaching out to a technician to get out there and they're not available to come out the next day, and it's going to take them a week to come out, then that's understandable. What I would try to do is provide, a tenant with, another refrigerator for the time being.
Oh, you know what? He did say it was actually tenant owned.
If it was tenant owned, when this law has just come out, does it apply retroactively? It's unclear, but if the tenant owns a refrigerator and the lease agreement states that the landlord hasn't provided a refrigerator at that time, then I would put the onus on the tenant to repair it.
Mhm.
But again, it really depends on, where the property is situated, if it's a LA RSO, because, again, depending on the jurisdiction, tenants have a lot more
And then
protection.
also, like for existing lease agreements, we did create Form 209, which is, this mandatory appliance deal. And just take a look at it, read through that. I know one person asked about what what kind of properties are exempt from the law. And in that, and also in the lease agreement, there's several, the property types are listed that are exempt from it, but it doesn't matter if it's a single family home or multifamily, like it's literally like building code. It's part of habitability. And
Yeah.
this is a big topic that we don't know about yet, because like it's going to be a year or two. All the attorneys, they're like asking me in a year or two, but I think we will
Yeah.
cover it just because everybody has questions about it, and there's a lot of questions about it. So we will
Yeah.
get a topic. But yeah. And then, okay, Zuli, go ahead and unmute yourself.
Hello, good morning.
Good morning.
I have a fourplex in Los Angeles. This is at unincorporated area of Los Angeles. And there are four single-family residents completely separate from each other. I have this tenant that the daughter used to live with them, and then she moved out, and now she came back with the husband and a kid, but they don't want to provide me their contact information of any document to put them in my file. What can I do in that case?
Did you ever have when the daughter moved out, was she on the lease agreement? The
No,
original lease?
no.
Was she a minor at that time when she
Yes.
moved? She was living
Yes.
there?
Well, yes.
Okay. And then she moved out, and then she came. When she moved out, was she a adult at that time when she left?
Yes.
Okay. And there was nothing. Was there anything in writing that she's no longer living there?
No. She just left. We didn't notice, and long time later, we noticed that, but no one said anything. And then years later, she came back with the husband and a kid.
Yeah. So, and there was no new lease agreement drafted at all.
No.
No. Okay. Well, at that point, when it comes, and who's paying the rent?
The parents.
The parents are paying the rent. And how do you know that she moved back in?
Uh,
What kind of
because
evidence do you have?
yeah,
of that?
we see them all the time in the property.
Okay. When it comes to unauthorized occupants, I always tell my clients it's imperative to be able to have enough evidence to be able to establish that they're actually living there. So I have a lot of, for example, when I asked you, how do you know they live there? And you told me, oh, I see them there. It's different as to establishing that they're actually living out of there. So what I tell my clients to do a lot of times is see if you could see any mail that's coming to the property that's not the named tenant. Or if you have cameras on the property and showing the individual coming in at night and leaving in the morning. That way we could establish that this individual is living out there.
Mm-hmm.
Trying to cite them, or if you're intention is to evict them for this basis, it's going to really require a lot of evidentiary, documentation for me to establish that that individual is actually living there.
But I already requested their information. We know that they're living there, they sleep there, and they have all their belongings there, and they receive mail also there. So we are sure that they're living at the property. But how can I force them or obtain their contact information in case I need to act or do something with them in the future?
What I would do, the lease agreement that you have, is it an AOA lease?
No,
No lease, they said, right? She
I
doesn't
have a
Okay.
lease, but it's not an AOA.
Oh, okay.
Okay, is it written? It's written, right?
Yes, yes. Right
I'll
now
have
it's a
to-
month to month.
I'll have to, yeah, I know reverse. I'll have to take a look at the lease agreement. So if you want, call my office. We could schedule a 15-minute consultation. I'll review the lease, and I could give you your options that you could take.
Okay. All right. Thank you very much. I will do that.
Thank you.
My
And
pleasure.
then go ahead and lower your hand and mute yourself. And one of the things that one of the questions, I know there's a lot of questions, and I'm really glad that you went over the pet rent. And I think that's such an area where people are going to get tripped up and potentially have an illegal rent increase. Bijan.
Yeah. Let me clarify that. If you have a property that is situated in the city of Los Angeles that is rent controlled, there is only a specific amount of percentage you could increase the rent by. I believe this year it's at 3%, and you could apply an additional 1% for if you're paying for gas or electricity for the tenant. That's the only amount that you could be able to increase the rent by. So if there is an additional pet or to that effect, under the LA RSO law, you cannot increase it more than that 3%. The only way that you can increase it by more than 3% is if you're paying gas and electric, and that's only at 1%.
Right. And the other thing that trips people up, specific to LARSO, you can charge an extra 10% for additional renters that are coming in, not additional dependents, but additional
Correct.
renters, adults that are coming in. That one will trip people up because, and that are outside of LARSO, they'll think that maybe they can do that, but that provision is specifically there because it's because of LARSO and their specific, their allowance of that. And so,
That's
yeah,
correct.
people get that's why going through these things is good, because, when you're filling it out or what you think you can do, you may, just because it's there doesn't mean it applies to your property type, right?
Yeah, absolutely.
All right, Ernest Moore, if you could unmute yourself and ask your question.
Okay, I have a 8-unit apartment building that I inherited, and the first big question is that when I acquired the property, they only gave me security deposit for one of the tenants. And I guess my question is, how should I proceed on the security deposit situation? As I've talked to the tenants, and they said, well, when they changed, we never got our security back from the previous management company. And I've tried to contact them, and they say that, the management companies, and they say, oh, well, it was too long ago, and we don't have the security deposits.
Okay. And you inherited this property?
Yes,
Where is the property located?
Los Angeles. It's under rent control.
Yeah. Is there lease agreements?
That's what I'm working on now to give each of the tenants a new current lease agreement.
Well, was there ever a written lease agreement between you and the tenant?
Yeah, most of them say no. Now, one tenant said that she had a lease agreement from back in 2017 and she refuses to sign a new lease agreement with me, but she's only shown me like part of one page.
Hmm. But you don't have any of the leases.
No. That's the other thing,
Yeah,
right? Got the
that's gonna be
property.
that's gonna be a little difficult, which is why it's so important to have lease agreements. Again, I understand your situation is a little bit minute because of the fact that you inherited the property, so you're kind of stuck with what you have right now. Um, it's a little bit difficult for rent control property, especially to be able to, put them in a position in regards to the security deposit or any breaches in the lease because you don't have it, right? I think the best advice that I can give on that is try to obtain it. See if you could get the tenant to give it to you, or reach out to that property management company that was, managing the property because without a lease agreement, it's going to be very hard to enforce anything.
Yeah. Most of them have agreed that they would allow me or they would sign a new lease agreement, but the question is about the security deposit. Can I say, well, security deposit will be determined once I've contacted the previous management companies, or can I do say make it in payments or something, or break it down?
I would try to ask them. I would try to ask them and see, if they're claiming that they did make a security deposit, do they have any proof to that effect that they did that? Whether if it's through, a check payment, or if they say that, they had a lease and the
Right.
lease states it, show me the lease that states it, right? That way you could be able to establish to see, how you could proceed. I mean, if you're generating a new lease agreement with them and they're obviously it's mutually agreed upon, right? So if in the lease agreement it states that, they're going to have to, put up a security deposit, then that's what they're agreeing to. But I think this is a good way for you to be able to obtain any proof of the previous security deposits paid, or any, even the lease agreement itself, by asking them, saying, okay, if you're telling me that you paid security deposit before, is there any way you could provide with any documentation to that, whether if it's the lease agreement, whether if it's a check stub, something. And that way it'll give you more clarity on how you could proceed.
Yes. Now, if they don't have any documentation that they paid a prior security deposit or their lease agreement, can
And,
can,
it, and
can I compel them to pay me a security deposit?
compelling, no. You cannot compel them. But again, if they sign a new lease,
Yeah.
the lease agreement, memorializes that, there's a security deposit, then that's a difference because that's mutually agreed upon. But if you're asking me that if you could force them to pay a new security deposit and compel them to do that, I would say no, given the fact that they're already in possession.
All right, thanks, Ernest. And yeah, so go ahead, lower your hand. And there's lots of questions and definitely running out of time. So let's limit to just one question per person. And Kevin, thank you for patiently waiting there. Go ahead and unmute yourself. Go for it.
Can you hear me?
All right, I can hear you. Yeah.
Hi. Hello again. Thank you for a great meeting lecture. I appreciate you guys. Question I have, if I may, on item number 44. Please specify if you can, if the property is LA City RSO or LA County RSO. So do we check off the box for subject to statewide? because they are still subject to the local ordinances. So do we still say subject to statewide? Yes. Is that what's going to happen?
Well, if the property has a local RSO, is it a multifamily?
Yeah, multifamily RSO, LA City, and another property, multifamily LA County RSO. Yes.
Then I would check off that it is subject to the statewide rent control.
Because I
But again,
thought for
it doesn't.
some reason,
I want you to understand this.
Uh,
This if you have a local rent control, the statewide AB 1482 has no application to you because the local ordinance is what is taken over.
so what should we
So
check it off then? What should we say that it is?
I'll tell you right now. Let me just take a look at this real quick.
I understand if it's a single family home or a condo, I understand it doesn't that's different, but this is multifamily.
I'll tell you right now. I look at the statute so many times. And I would say
And then, yeah, oh, never mind. I'll let you.
go ahead, Jeff, if you have.
Oh, no, that's okay. I'll let you. We've got to kind of focus.
Yeah.
I'm thinking of the next thing already.
Okay. This is very important. I really like your viewers to see this. If you guys can see my screen here, okay. This is AB 1482. This is the assembly bill. Okay. If you go down and if you go to subsection E, where it says this section shall not apply to the following types of residential real properties or residential circumstances. If you have a transient or tourist hotel, it doesn't apply to AB 1482. If you have any housing accommodations for nonprofit hospitals, religious facilities, and whatnot, it doesn't apply. Dormitories, housing accommodations in which tenants share bathrooms or kitchen facilities with the owner who maintains the principal residence of the residential real property, doesn't apply. Single family owner occupied residence, including residence in which the owner occupant rents or leases no more than 2 units or bedrooms, but is not limited to a accessory dwelling, doesn't apply. A duplex, in which the owner occupied one of the units as the owner's principal place of residence at the beginning of tenancy, so long as the owner continues occupancy. Housing that has been issued and certificate of occupancy within the last 15 years. So this AB, the Tenant Protection Act, which is formerly known as, it's on a rolling basis. So if there's a certificate of occupancy that is issued within the previous 15 years, it doesn't apply. Residential real property is alienable, which is pretty much single family homes. That is the best way to put it. So these are where the properties do not apply. This is where it's exempt. These are the reasonings as to why the property is exempt under the Statewide Rent Control Act. If you go down here, okay. This section does not apply to the following residential real properties. Residential real properties subject to local ordinances, okay, requiring just cause for termination. So in the circumstances for you, because that there is a local residence, that there's a local ordinance that requires just cause eviction, this portion will not apply to that. Now, for the purposes of the lease agreement, if you're going back to establish if this property is subject to the statewide rent control, it is. It is. Based off of what the statute reads, it is subject to statewide rent control because it is a multifamily, and in addition to that, depending on when the property, if you don't have a certificate of occupancy with that is within the 15 years, then it is subject to that. So I would check off that the property is subject to state rent control. But you have to understand that the local municipal rent control overrides this. So it doesn't matter. But for the purposes of lease agreement, I would check this off. Yes.
Okay, sounds good. Thank you very much.
Great.
Of
And then
course.
in the chat, one thing that was brought up is that on the LA housing side, it says that the 1% for the utilities is no longer allowed.
That law is going to apply after February of I have it right here.
It says beginning February 2nd, 2026, a landlord can no
February
longer
2nd,
include.
2026. And this is really, and I want to show the viewers this too, so they can understand, what everybody has to go through. And I think this is very informative for the viewers to see.
And there are times when information on government websites is wrong. It can be inaccurate or just flat out wrong at times.
It is. And there is a discrepancy here because if you look,
so if I remember right, it seems like they took away one, but they kept one. Like they're
yeah. So
I
if
don't
you
remember.
see here, if you
Yeah.
ever go on the LAHT website, they provide their updates for landlords. And over here it says, this is the new law that is going into effect February 2nd, in which you can no longer include an additional 1% for gas or electric. But if you go down here, it's funny because if you look at RSO annual rent increases, it states here that effective July 1st, 2025 through June 30th, 2026 is 3%. If the landlord provides gas and electric services to tenant, an additional 1% could be added. So it kind of it's ambiguous as far as what you can and can't do, because if you look, the law actually went into effect on February 2nd. So now landlords don't know whether if they could increase that additional 1%. But for the purposes, and again, if you guys want to, I'm going to look deeper into this, which I've had this issue happen a lot of times. But for the purposes of doing an increase out of the abundance of caution, if it is between that period, then you don't need to include the 1%. But it clearly states here that between this period, you could do 3% and include additional 1%. Now, whether this is accurate or not, I've seen, like what Jeff said, governmental agencies, they make mistakes all the time. So if you have a question about it, just call my office and I could dive a little bit more deeper into what we could do. But as you can see, 3% is a cap.
Hey, and right now, I just want to respect your time. It is like we're
course.
past 11:30, and that's like when you usually are, have other things planned and everything. If we were to copy some of the questions, there's a bunch of questions on YouTube as well. If people were to put their questions in the chat here, and we got that to you in writing, would you be able to answer those? And then we could get that back up
100%.
there? Okay,
Of
so
course.
that's one thing.
Yeah.
You can call him directly. His number is there. The 424-220-2052, is it? I'm looking at this little tiny window. And so give him a call there directly with it. And then so we'll get these questions answered, and we'll kind of put together like a little legal Q&A, like from the Zoom meeting. We'll do that. We just did that for Brennan, and we'll be putting that out as an email as well. So I know there's a lot of questions, and whenever they change everything on us, like, what are you supposed to do? Of course, you're going to have questions, and that's why we try to do these and just keep everybody up to date. So we thank you guys so much. I know many of you are members, and we're gonna keep grinding, and hope you do too. And yeah, so we'll see you next week. Take care.
Thank you so much, Jeff. Thank you, everyone. Thank you.
Yeah. So